I have been on this bench for a long time, long enough to know that people do not always come into court carrying what the paperwork says they are carrying. On paper, it may be a contract dispute, an unpaid bill, a damaged car, a small injury, or a workplace complaint. But in real life, people often arrive carrying something much larger: pride, fear, resentment, desperation. Sometimes they bring a story carefully built to get sympathy. And once in a while, someone walks in carrying a performance so polished, so calculated, that the first task of the court is not simply to hear testimony, it is to separate reality from theater. That was the situation the morning Karen Whitmore entered my courtroom. She was 48 years old, dressed beautifully, composed on the surface, and carrying a white cane with a kind of practiced fragility that immediately drew attention. She moved slowly, deliberately. Her hand reached into space in a way that seemed almost designed to make every person in the room uncomfortable, for even wondering whether anything about her presentation might be exaggerated. The performance was not loud. In some ways, that made it more effective. She had clearly studied what she wanted people to believe about her. She had chosen the right accessories, the right pacing, the right pauses, the right expression of vulnerable determination. To an untrained eye, she might have looked convincing. But I have spent too many years watching people tell stories from witness chairs and counsel tables to ignore instinct when instinct starts speaking clearly. Karen had filed a lawsuit against Barbara Chen, a 52-year-old woman who owned a small accounting firm. Barbara was not a giant corporation. She was not a faceless employer with an army of attorneys and a public relations team. She was the kind of person who builds a business slowly, carefully, and at personal risk. She had hired Karen 8 months earlier as a bookkeeper. According to Karen's lawsuit, she had developed a rare condition that left her blind, and Barbara, rather than accommodating her disability, had terminated her and forced her into financial and emotional distress. Karen was asking for $125,000 in damages, claiming discrimination, wrongful termination, and emotional suffering. Barbara sat at the defense table looking exhausted, truly exhausted. Not the theatrical exhaustion of someone putting on an act for a judge, but the drained, brittle expression of a person who had spent months paying legal fees to defend herself against something she believed was entirely false. She had already spent $12,000 just trying to keep her business and reputation intact. And before the hearing even began, I could see that she was less angry than stunned. That kind of stunned expression comes from discovering that someone you tried to help has chosen to turn your decency into a weapon against you. The more I reviewed the file, the more my instincts sharpened. Barbara's account was simple. When Karen first announced that she was losing her vision, Barbara had tried to help. Flexible hours, adjusted responsibilities, patience. But then, according to Barbara and several co-workers, small contradictions began piling up. Karen claimed she could not read documents, yet co-workers reported seeing her glance at her phone and respond to messages without assistive tools. She claimed she needed help navigating, yet internal security footage appeared to show her moving through the office smoothly when she thought nobody was watching. There were reports of her driving in the parking lot, reports of her identifying objects at distances that did not fit the story she was telling. When Barbara confronted her gently about the inconsistencies, the relationship collapsed. And shortly after that, the lawsuit arrived. Barbara also described the emotional damage the fraud had caused inside her office. She had a staff of 9 people, small place, family atmosphere. Some of them had gone out of their way to help Karen after the announcement about her eyesight. They had carried files for her, read screens aloud, reorganized desks and walkways, slowed their own work so she would not feel embarrassed. Barbara told me they did all of that willingly because they believed they were helping a colleague through a devastating medical change. Then, piece by piece, they began realizing they were not watching courage. They were watching theater. Nothing poisons a workplace like finding out your kindness has been turned into a resource to be exploited. One of Barbara's employees had provided a statement saying she watched Karen claim she could not read a printed ledger, only to glance at a text message on her phone 2 minutes later and laugh at something on the screen. Another said Karen once asked for assistance walking to the restroom, while at the same time accurately reaching for a coffee mug placed several feet away on a crowded desk. A third employee reported seeing Karen apply eyeliner in a car mirror during lunch. These were not isolated slips. They were the kinds of mistakes people make when they are lying full-time and get tired of remembering which version of themselves is supposed to be present. I take disability fraud seriously, extremely seriously. Not because I enjoy catching liars, though I have no patience for dishonesty, but because false claims like these damage real people. They mock individuals who live with actual impairments. They poison trust. They make employers, insurers, coworkers, and even courts more skeptical when a genuinely disabled person asks for help or legal protection. Fraud in this area does not merely steal money, it steals credibility from people who cannot afford to lose it. Years ago, I presided over a guardianship issue involving a young man who had lost most of his sight after a violent assault. He needed help reading, navigating unfamiliar places, and doing work he once handled easily. What struck me most about him was not weakness, but discipline. Every movement had intention. Every adaptation had cost him time and training. Nothing about his life resembled the broad, melodramatic gestures Karen was performing in my courtroom. Real impairment changes rhythm. It changes habits. It does not arrive like a costume assembled from internet research. So before Karen ever took the stand, I had already done what any careful judge should do when something feels wrong. I had looked more closely. I had asked questions. I had made calls. And I had arranged for the hearing to proceed in a very deliberate way. When the matter began, I asked Karen to explain her condition in her own words. She took a deep breath and delivered a practiced narrative. She said that 6 months earlier, she had woken up and found that her world had gone dark. She said doctors had diagnosed a rare degenerative condition affecting her optic nerves. She said she had gone from independence to helplessness overnight. She described the loss with a careful blend of sorrow and poise, the kind designed to suggest that she was brave enough to endure hardship, but wounded enough to deserve relief. Then she turned toward Barbara and described herself as a loyal employee, discarded the moment her disability became inconvenient. It was polished. It was emotionally calibrated, and it did not move me. What did interest me was the way she used language. Fraudsters often overwrite their hardship. They do not simply say, "I lost vision." They speak in highly packaged phrases. Their story sounds narrated, not lived. Karen used all the right emotional notes, but she did not sound like someone groping for truth. She sounded like someone presenting a product. I turned to Barbara and asked for her response. Barbara's voice shook, but her account stayed focused. She said she had not fired Karen because of a disability. She said she had fired Karen because she believed Karen was lying. She referred to office security footage, witness statements, inconsistencies, social media activity that did not align with blindness. Karen interrupted almost immediately to call the material misleading and discriminatory. She framed skepticism itself as cruelty, which is a very common technique in fraud. If you can turn every factual question into an act of persecution, you force decent people to feel guilty for testing the truth. Then I brought up the medical documentation. Karen had submitted a letter from an ophthalmologist, Dr. Michael Stevens, confirming her diagnosis. The problem was that Dr. Stevens had retired months earlier and had not treated patients during the period in question. I had spoken with his office. The letter submitted to the court bore a signature that appeared to imitate his, but badly. When I informed Karen of that fact, her composure flickered for the first time. She tried to suggest confusion, maybe a different doctor with the same name. But the moment had already shifted. The court now had a forged medical letter sitting in evidence. That is not a clerical error. That is not a misunderstanding. That is design. Even then, Karen did not retreat. She escalated. She insisted she was genuinely blind and accused everyone around her of wanting to shame disabled people for adapting. The language was familiar. She wanted the room to feel afraid of appearing insensitive. But truth cannot be held hostage by manners. If the evidence points to fraud, my job is not to worry about the comfort of the lie. My job is to expose it. So I conducted the first simple test. I asked Karen to demonstrate how she used her white cane to navigate from one position in the courtroom to another. If someone has been living with blindness, especially if that person is relying on a cane, there are patterns of use that become second nature. What Karen displayed was not second nature. It was imitation. She waved the cane like a prop, not a tool. She moved it broadly, awkwardly, without the controlled arc that actual mobility training teaches. It looked like what a sighted person thinks blindness looks like when they have learned it from movies and internet clips rather than lived experience. When I pointed that out, she reacted exactly as frauds often do when they are cornered by specifics. She became louder, more indignant, more moralistic. She said the court was humiliating her. She said this was why disabled people stayed silent. But outrage is not evidence. Volume is not proof. And my patience for manipulative theatrics is very limited. At that point, I introduced another line of evidence. Social media. People delete things all the time, then act surprised when the digital record does not vanish as cleanly as they hoped. Karen had posts and location-linked content that placed her at a shooting range just weeks after claiming total blindness. The images showed her handling a firearm and accurately hitting targets. When I asked how a completely blind person manages target shooting with apparent confidence and coordination, she said the images were old. They were not. Metadata is indifferent to panic. Dates, locations, and transaction records told their own story. There was more. She had restaurant photos in low light where she was reading menus. She had tagged herself at a boutique opening while carrying no cane at all. There was a video clip from a friend's birthday dinner where she turned instantly toward a phone flash from across the table. None of those items alone would have proved the entire case, but together they established a very clear theme. Her blindness appeared to arrive when money, leverage, and sympathy were useful, and disappear when comfort, pleasure, or spontaneity required sight. The courtroom had turned by then, not because I raised my voice. I did not need to. The evidence was doing the work. Barbara sat straighter. Karen sat tighter. The audience moved from sympathy to suspicion and from suspicion to recognition. The only thing left was to make the truth visible in a way no one could deny. That was when I brought in Bailey. Bailey was a golden retriever.
I've been on this bench long enough to know that people don't walk into a courtroom carrying only what their paperwork says. On paper, it might be a contract dispute, an unpaid bill, a minor injury, or a workplace complaint. But in reality, people bring much more: pride, fear, resentment, desperation. Sometimes they bring carefully crafted stories designed to win sympathy. And once in a while, someone arrives with a performance so polished that the court's first job isn't just to hear testimony, it's to separate truth from theater. That's exactly what happened the morning Karen Whitmore walked into my courtroom. She was 48, well-dressed, composed, and carried a white cane with practiced fragility. Every movement felt deliberate, measured in a way that discouraged anyone from questioning her. It wasn't loud or dramatic, which made it more convincing. To most, she might have seemed credible. To me, something felt rehearsed. Karen had filed a lawsuit against Barbara Chen, a small business owner who ran an accounting firm. She wasn't a corporation with endless resources, just someone who had built her business slowly and carefully. Karen claimed that she had gone blind due to a rare condition and that Barbara had fired her instead of accommodating her disability. She was seeking $125,000 in damages. Barbara, sitting at the defense table, didn't look angry, just exhausted. The kind of exhaustion that comes from being blindsided by someone you tried to help. According to Barbara, when Karen first reported losing her vision, she did everything she could to support her, adjusting responsibilities, offering flexibility, and encouraging the team to help. And they did. Staff went out of their way to assist her, believing they were supporting a colleague in need. But then, things didn't add up. Karen claimed she couldn't read documents, yet coworkers saw her checking messages on her phone. She said she needed help navigating, but security footage showed her moving around the